Hi, good afternoon, everyone. My name is Laura Bacchus, and I'm the director of Dykema's Automotive Industry Group. Thank you, everyone, today for joining us for our next installment of our 2024 Dykema Drives webinar. Today, we're going to be speaking about EV and AV, specifically related to some litigation updates, best practices with negotiating, as well as environmental issues related to batteries. This is a CLE webinar, so please follow the instructions here, which will be provided to you after the fact if you are interested in getting credit. A little bit about Dykema for those that don't know us. We're a national firm. We have coverage throughout the states, particularly our automotive industry group, which is upwards of well over 100 people in all areas of the law, from regulatory to litigation to transactional, IP, environmental, and everything in between. If you haven't had a chance to read our 2024 Automotive Trends Report, please feel free to reach out to me afterwards, or you can use this QR link on the PowerPoint that'll be sent to you afterwards. Today, we're going to be hearing from Mike Carey, one of our prominent litigators and co-leads our EV-AV team at Dykema. I was going to be speaking about AV litigation specifically, followed by Mark Malvin, the other co-lead of our EAV team. Mark is a transactional attorney. He will be speaking about some of the best practices for negotiating AV contracts and particular risks you should be looking for. Next up will be Grant Gillison. Grant is the director of our environmental group here at Dykema. And not surprisingly, there's many environmental issues with regard to batteries, and Grant will be speaking about those. And then finally, cleanup, if you will, but not really. We have Connor Walby. He's a member in our Bloomfield Hills office. He currently is involved in several lawsuits with regard to battery fires and EV litigation that he'll be speaking about. So thank you, everyone, for joining us today. Feel free to read the detailed bios later. If you have questions, there is a Q&A function. Feel free to put it in there. Email any of us after the fact. I don't know if we'll have time during this presentation to answer, but we'll certainly, if you keep your name in there, get back with you afterwards. Thank you. Mark?
I think I'm actually up first, Laura.
Okay. Sorry about that.
That's
Mike?
okay. Thanks, Laura. So as Laura mentioned, I'm Michael Carey. I'm in the Minneapolis office of Dykema. I'm a trial lawyer, and I'm going to talk a little bit about autonomous vehicle litigation trends. And as we talk about that, the first thing I want to say is there really aren't a lot of purely autonomous vehicles that would qualify under the SAE taxonomy as level 4 and 5 on the roads yet. And so not surprisingly, we don't have any litigation trends to report in terms of verdicts. I can report that there are some cases that have now been filed around some of the limited uses of autonomous vehicles in certain markets, San Francisco, Phoenix. We're starting to see some cases, but we haven't seen really how they're going to bear out in terms of what jurors are thinking of them. So I wanted to talk, though, just sort of more broadly about why, what we're thinking about as we move toward getting to a world where we have autonomous vehicles and what liability pictures will look like. The biggest thing that I see in thinking about this is the epidemic of distracted and impaired driving, that autonomous vehicles don't have that problem. They also provide a lot of efficiencies and convenience. The bad thing about them is, people I think still have a lot of fear, and that there, for our industry, is an uncertain landscape of liability. The graphic on the lower right is something that I came across, I think 4 or 5 years ago, and to me, it's helpful and comforting to think about what the future looks like for liability for autonomous vehicles, and that is that there will probably be fewer crashes. And even if the folks, the OEMs, the suppliers that are in this space may bear more responsibility for crashes that do occur because we don't have perhaps a driver who actually caused the crash, who's at fault, but the vehicle is driving in some sense. There might be a greater proportion of liability of the cases that are out there, but there should be fewer crashes. So what that actual, pie shape is going to look like, we won't know for many years. But I do think that that's a likely anticipated outcome, that there would just be fewer crashes. And I think, in the end, that's the goal for everybody. And that's why this technology is so promising for everybody. All right. So while we don't have any true AV crashes yet, we have a lot in the space of ADAS. And there is a lot of litigation in this space right now. I've listed several of the defense verdicts that have come in. You'll notice that there are no plaintiff verdicts. I'm not aware, and I sort of survey this area, of any reported jury verdicts or bench trials where an ADAS system at any level has been found to be defective and there's been an adverse verdict. But there, as you see here, have been multiple defense verdicts. I think this is really encouraging in terms of the litigation trend, that when we're putting this issue in front of jurors, they're reaching a conclusion that isn't a knee-jerk reaction, fear of technology. They're able to sort through the issues. You see this most recent one was a forward collision warning AB case. It was tried in Missouri. A gentleman named Tom Bazemore did a great job. And if anybody has any questions, a little deeper on that, who are the experts? We don't have time to cover all that today, but I can, you can reach out to me separately and we can talk about a little about that. All right, so just in general, the liability landscape in this area, from my perspective, is coming down to two sort of general buckets. And they're reminiscent of what we saw in traditional crashworthiness liability, like seatbelts, airbag type stuff. And it's failure to equip cases. In other words, the vehicle doesn't have a particular technology, AEB, lane departure warning, backup warning, those sorts of things. But everybody else in the industry did. And that's an easy claim for plaintiffs to present. If you have a vehicle on the road that's, like a 2019-ish, and it does not have forward collision warning or AEB, and you have a rear end collision, because a lot of cars in that time frame do have that technology, plaintiff's lawyer can say, hey, this was available. We know it works. You should have put that on there. So we're seeing a lot of those claims. The other one we're seeing is failure to perform. And I put the technology failed to prevent a crash. And I think that's, sort of a reflection of a misnomer in a lot of these technologies. They're not crash prevention technologies. They're really intended as crash mitigation. They work in a lot of circumstances and they're helpful to back up a driver, but they're not intended to keep you completely out of accidents. If they do, that's a bonus. But hopefully what they do is reduce the severity of a crash. And so that's something that, as we're looking at defending these cases, we're trying to emphasize. The other thing that we're seeing in failure to perform is, allegations that the technology did something unexpectedly. Not that it just didn't prevent a crash, but that it steered on its own or that it braked on its own. And those are interesting types of claims. So I think those are, in general, two buckets of liability or litigation trends that we're seeing in this space. Just quickly, by far from what, sort of anecdotally, in talking with others that do the kind of work that I do, the most common technology that's at issue in ADAS litigation is forward collision warning and AEB. I sort of alluded to it a minute ago. I think that there was a commitment some years ago, I think 2017-ish, that by 2020, all the vehicles would, everybody would have standard AEB. That chart on the right is from the NHTSA reporting website showing the progress. Some companies, for example, Tesla, has had 100% AEB on its vehicles since 2017, on up to, at the top, JLR's still working on it. Another thing, people may not be aware that recently, Federal Motor Vehicle Safety Standard 127 was in the rulemaking process and announced formally this May. It does make AEB, including for pedestrian, standard by 2029. That's a ways out, so it's going to take a while to get there, and there's a phase in. And there are some unique requirements in there that I think a lot of the people in the industry and engineering side are looking at that are going to be difficult to meet. So we'll see how that goes. And, I wouldn't be surprised if there's some modifications on the standard, just in terms of feasibility of achieving what they've put in there so far. All right, just sort of more theoretical type topic now. I always ask this question. We first got into the crashworthiness doctrine in 1968. It was a long time ago. And that was just that you had an expectation as a driver that your car would keep you safe from enhanced injury or second collision. Before 1968, if you got in a car crash and your seatbelt, or there weren't a lot of seatbelts then, but your car did something that, perhaps enhanced your injury, you were on your own. But the birth of product liability for automotive was really this time frame, and it's turned into what we see today. And for the most part, that same model is being overlaid onto autonomous vehicle technologies. And we saw that with things like electronic stability control about a decade ago. I think it's an early iteration of an ADAS system. And so I don't want to say I coined this term, but I thought of this idea of we had crashworthiness. Now we have sort of crash avoidiness. But the bottom line is that in every state, the driver is ultimately responsible for controlling the vehicle. And one of the forefront cases right now that is testing this theory is a case against Toyota. It involves lane departure technology, and Toyota won a summary judgment motion in Arizona, essentially arguing that it doesn't have a duty to put this technology in every car because the cars are by themselves safe. They also won on a number of other arguments, including causation, and it's now before the Arizona Court of Appeals. Oral argument was just 14 days ago. Amanda Heights from Bowman and Brook, one of my friends, did a fabulous job, and if you guys are interested, you can listen to it online. It's all recorded, but it really is at the cutting edge of where we're going in terms of automaker liability for putting this technology in vehicles. All right, I'm getting close to my time, so I'm going to move through these next slides pretty quickly. When we think about the ADAS landscape, one of the things that's I think probably the prominent defense is, if equipped, would have it changed the outcome? And I think a good example of that is lane departure assist or lane departure warning technologies. People on the plaintiff side like to think, hey, if you just put this technology in, this person wouldn't have left the roadway, they wouldn't have come across the center line, et cetera. That's not always the case. Again, the technology is meant to be assistive and provide the driver with cues, but the driver has to respond to that. And in a lot of instances, what we're seeing is people who are either under the influence of drugs or alcohol, they're asleep. And so no matter, what the car was telling them, or beeping at them or buzzing at them or giving them a visual alert, it's not going to make a difference when somebody's driving in that impaired state. Another one would be, if equipped, would have it changed the outcome? I alluded to this earlier. AEB systems work most of the time and they work very well, but there's a lot of scenarios where just because of the circumstances, you have a vehicle that's sideways, it doesn't look like a vehicle, it's not illuminated properly. The system isn't going to throw the brakes on for you. And that's to be expected. You don't want it always doing that. And the other thing, of course, is that AEB systems are intended to mitigate crash severity. If you don't get into a crash because your AEB kicks on, that's great, but that shouldn't be the expectation. Oops. And then finally, I just want to raise some other considerations for people who are thinking about these types of cases. I had to throw in a Drake meme. It was my first Drake meme that I made. Annoying FCW, forward collision alert. When you're paying attention, everybody is familiar with that. You're coming up. You're going to stop in time. You can see the car ahead of you slowing down, and all of a sudden you get beeps and alerts, and that's annoying. But it's okay when AEV prevents the crash when you're not paying attention. And I think that gets to sort of some of these other considerations. A lot of people, when we talk to focus groups, we've talked to jury panels, and just, hearing from some of the experts we work with and the human factors side, uh, a lot of people aren't into this technology. They don't want it. So either they're not buying cars with it, or once they have it on their vehicle, a lot of it you can disable, and they choose to do that. So it's sort of interesting when you get into a litigation setting, when a plaintiff is saying, you got to have this on there, it's got to be there. And many of the jurors might be sitting there saying, I don't want this. Or I'm not all that interested in it. The demand from consumers isn't quite there to having the expectation that it's always going to be on every vehicle. And then, of course, something we deal with in all of our auto product liability cases is this technology is not cheap. There's high cost to integrating it into vehicles. So what we see is earlier, more expensive, newer models getting that technology first. Lends to the argument that plaintiffs sometimes make, which is that, is safety only for the rich? And the answer is, well, initially it sort of is, because that's who's buying the product, that's sort of subsidizing the R&D that goes into and bringing the cost down for everybody else who's buying the lower and more entry-level vehicles. And of course, it introduces, when you have all the different sensors and cameras and calibrations, a whole nother level of repair and maintenance, because you just have this entire system running on top of all the vehicles' primary systems that allow it to move. So I don't have anything else. I'll kick it over to Mark Malvin next. And if you have any questions, throw them in the chat. And like I said, I'll be available to answer or talk offline if anybody wants to reach out.
Thank you, Mike. So as Laura mentioned, I'm a transactional attorney. I'm the leader of our tech transactions and sourcing practice and co-leader of our AV and EV and mobility practice. And I'm here to talk about strategic partnerships and how to allocate responsibility between them. At least a couple things about that. But I guess the first thing I would note is that our firm, we have a deep expertise in both tech transactions and automotive. And so we've been at the forefront of negotiating many of the industry leading strategic partnerships in the AV space. And so I'm going to highlight just a couple of select issues that we've had to address in those negotiations. And the first thing I think I should say is that there's quite a bit of variability in the relationship in the strategic partner. It's not necessarily the typical tier 1 to OEM relationship. In some cases, we have the AV technology company being the customer, acquiring vehicles from an automaker. In other scenarios, we'll have the AV company acting as the OEM and assembling a bespoke vehicle. And in the commercial vehicle space, we see often a more triangular relationship, I guess you could say, where the AV company works with the vehicle manufacturer to design a system that combines their products, and then the commercial customer will buy the vehicle with the AV hardware and then subscribe to the self-driving system, enter a subscription with the AV company. And at least two of these scenarios, the parties are going to need to address something that is in the normal scenarios, not that big a deal or not that controversial, and that is change management. And the reason for that is it is normal. I mean, I'm telling you guys what you already know in some respects, which I'm told is one of my gifts, by the way, speaking the obvious, that it is normal and necessary for vehicle manufacturers to make ongoing changes during a production run. But changes to an underlying base vehicle can have adverse effects on the performance of a self-driving system. That's because there's a lot of interfaces, there's interactions between the system and the vehicle. And so what you end up needing to do is getting very granular about how change management is going to happen, more than you would in other relationships. And And I guess I would say that the bottom line is that both sides have to look at things from the other perspective and work out a mutually workable arrangement in this area. In some of the negotiations, that has taken some time, and it does require patience and understanding on both sides, because it is something that's relatively unique to autonomous vehicle systems and strategic partnerships. So as I mentioned, we've come up with a lot of best practices for allocating PO liability, and I'm just going to touch on a couple of them. But big picture wise, the allocation of responsibility needs to be, written down, relatively detailed, and it'll largely be based on fault, which is what you would expect. But you have a couple of unique elements. One is the interface, which may be co-developed, and also the boundaries may not be as clear as you might want. And so you'll have to put some thought in and some language into how responsibility, PL damages that might flow from the interface are going to be addressed. Another thing that has to be addressed is maintenance, which could have a relationship to the PL claims as well as repairs. And the parties are going to have to think about the third parties in this sphere, whether it's the OEM's dealers or other repair facilities. Those may or may not be treated as agents of one of the parties. They may not be. And so the parties have to think through how that's going to work in their provisions addressing the allocation of PL liability. And maybe I should take a step back, because what we have found seems to work best as far as the practical nature of these allocations is that we often put together a schedule to the main strategic partnership agreement that goes into quite a bit of detail, many pages about how the parties are going to be behaving, what their obligations and duties are and responsibilities are to each other in a PL situation. And I'm going to get to those in a minute on the next slide. But I did want to talk about one more thing here, which is also unique to autonomous vehicles, and that is the data. There is so much more data available from an AV system that will be relevant in a product liability situation. I don't think it's really played out yet in the trials, and I'm interested to see how it will play out, because there's going to be a lot more information about who's at fault, what the vehicle was doing, what the other parties, what the other vehicles, what the pedestrians, what was going on around the vehicle. There's going to be a lot more information about that. And that'll probably change the trial strategies and dynamics. But it also is something that has to be addressed in the strategic partnership agreement, because the parties are going to, both parties are going to want access to data that might be held by the other party. And so having some rules of the road for sharing data, how that's done, what the procedures might be, is good for everybody. So as I mentioned, we often go into pretty great detail in our product liability appendix in the strategic partnership agreements. And I just want to cover a couple of the highlights. And before I get specific, I guess I would also say that some of these things are familiar. I mean, it is true, certainly, that automakers and their suppliers, their tier 1 suppliers or lower suppliers, have had to cooperate, have had to work together in the defense of product liability claims. I mean, that's been going on ever since there was product liability. And so some of these things are topics that either were generally understood or were trusted that the parties would work it out on an ad hoc basis. And generally, automakers and the suppliers are would cooperate in these scenarios. But we have concluded that in the AV space, and it was partly based on input from our clients, is that it's better for everybody to get more detailed, to actually be more specific in these relationship agreements about how the parties are going to relate to each other, how they're going to relate to the plaintiff's counsel, and what their rights and duties are in respect to each other in these scenarios. And actually, before I get into the details here, I guess I'll start at the top of my list. We also found that it made sense to include cybersecurity issues in the same appendix, because we found that the rights and duties were quite similar or identical, frankly, as far as the parties dealing with a claim that a party was harmed by a cybersecurity incident. And so that is definitely one of our best practices that we would recommend, is to include cyber. Some of these are, I guess, common sense. We want notice. Parties will want notice. It's beneficial to include some guidelines for the initial permitted actions before the parties ramp up their defense, to have no ambiguity about what a party who receives a claim can do to avoid prejudice. Some of these matters the parties will want to handle it jointly and have one party take the lead. In these scenarios, we concluded that some granularity about the selection of counsel, whether that's an agreed panel or a right of first refusal or consultation right, that varies based on the preferences of the party. The same with experts. And of course, experts is going to be a bigger and bigger deal. And so is discovery for AV, because there's an incredible amount of data. I don't think, and this is true in artificial intelligence generally, which is another part of my practice, and it is just not clear how these things are going to be handled at trial. There's so much data, and whether how much the experts can even see under the hood is kind of unknown, and what this means, whether it's helpful or hurtful in trial. And so getting into some granularity about the selection of experts and the procedures for discovery, we have found that both parties in these negotiations pretty uniformly have agreed that they mutually both felt that they were being benefited by getting into these in some granularity. Similarly with settlement, and there are, of course, different ways to address that I won't get into right now, given time. And the parties may decide to go jointly, they may decide to go independently, and they may need to address. There still needs to be, and this is true, of course, across the board. This part is not unique to AV, that the parties have a very strong interest in not shooting at each other, and not giving the plaintiffs a chance to divide and conquer and lead to unfortunate concessions or unfortunate circumstances. And then the last thing I'm going to talk about is dispute resolution in this context. We have, and our clients have concluded also here, that we want relatively detailed dispute resolution, both as it applies to disagreements about the implementation of the rights and duties, say about trial strategy, or whether somebody's complying with the various categories of issues on this list, but also around the allocation of responsibility ultimately between, say, the autonomous vehicle system and the underlying base vehicle. So I think I am right on time. So I am now going to hand it over to Grant to talk about EV and some important environmental concerns. I thank you all for your time and attention.
Thanks, Mark. Trying to get the slide to advance. There we go. All right. Well, there is indeed quite an environmental tale to tell about EVs before getting to the happy ending of zero emissions from the tailpipe. EVs, due to their lithium-ion or Li-ion batteries, involve significant environmental and sustainability implications. The current state of EV battery production, as it rests today, results in about the same amount of carbon emissions as driving a gasoline car 50,000 miles, and utilizes over 4,000 gallons of water to make each battery. Plug-in EVs draw on the electrical grid, largely sourced by coal and oil, and EV batteries contain mined critical materials like lithium, cobalt, and nickel, with a limited lifespan, all further adding to their embodied carbon footprint. Compared to ICE vehicles, EVs have more components containing PFAS and are heavier due to the large batteries, causing tires to generate more particulate matter into the air. And then there are the costs and risks associated with the cradle-to-grave environmental requirements for handling EV batteries due to their ignitable, reactive, and hazardous properties, which will be the focus of my overview today. So let's start our tour now of the Lion Den. As you know, there are four main forms of EVs, all of which contain Li-ion batteries: the traditional or starter hybrid, the plug-in hybrid, the battery plugged-in EV, and the fuel cell EV. Environmental protection requirements really involve two main points. One, to address protection of human health, the other, protection of the environment and natural resources. With respect to Li-ion batteries in EVs, that breaks down presently to three areas of regulation: transportation of the batteries, the handling of batteries, and the ultimate disposition of batteries, whether it be disposal, recycling, or reclamation. Starting first with their transportation. Again, EVs are recognized as a hazardous material in their original or virgin form, as produced, as new, unaffected. These batteries are relegated to that status because of both their chemical and electrical hazards. And that, again, includes when they're new as a result, and also as a result of any damage or events that may occur during their use. As that case would be, then regulations have developed that even in their new state, that EVs are subject to regulation, and it comes from the Department of Transportation. The slide has the citations, and I do believe the slide deck will be made available to everybody afterwards, so you'll have that resource for you. But that standard then sets forth packaging and labeling requirements for the new batteries. There is also the possibility of transportation by air, and it is permissible. And there are Federal Aviation Administration standards for such air travel of batteries. And it's under what is called the FAA Safe Cargo Initiative. But that also does include prohibitions, namely for damaged batteries. In looking at the shipping requirements, the key designation is the end-of-life status of the battery. So once new, once used, there then is the fate going forward. But that fate needs to be defined further in essentially the end-of-life or EOL definition. Breaks down to say, well, it can be deemed to be a used battery and not subject to more requirements than other traditional transportation requirements for the battery as if it were new, only if it doesn't have signs of damage, defects, or past fire events, thermal events. This adds to the compliance complexity for the batteries, because for those who are managing this, then there needs to be an appropriate determination of what is meant by damaged and defective. So there just isn't one bucket that can be used for used batteries when you need to transport them from either the dealers that are servicing them, or if it's under a warranty, back to a manufacturer, depending on however that is being coordinated, whether there needs to be some eyes on the battery and a compliance determination made about its state. So what is meant by damaged and defective EV batteries? Well, as listed in the bullets on this slide, and I know that the photo that's included in the slide, which was really to help make the point that as you're looking at it, you're really going to have to look at it closely, because it's not like a thermal event battery where it's just so scarred and burned that it's rather obvious compared to just a used battery. But you really do have to canvass it through all of the categories that are here. And the reasons why this is important from let's say a legal implication, a risk implication, is that ultimately you could have two forms of liability. One for improperly or violating transportation requirements for essentially transporting or shipping a battery that is damaged and defective that has not been designated as such and therefore not packaged and labeled as such. And then if en route that battery has some sort of an event where it has not been so properly labeled and packaged, and there is, again, some injury to a human as a result of it, some injury, damage to the environment, then you will have that liability. So both a violation, penalty, as well as possible damage and exposure in that manner. You look at thermal event batteries, this is a little bit easier because it's hardly recognizable as seen in the rather small photo here, that it's pretty charred. But nevertheless, there is a list here that would say that even in some events where there are thermal events that don't completely consume the battery, that there's determinations to be made, about that battery. And this is the roster that you would have to run through with your compliance in order to ensure your compliance. The packaging requirements for unused or batteries, let's say that aren't damaged and defective, they haven't gone through the thermal events, are pretty significant, even for the battery state, again, because it really does pose highly reactive chemical and electrical properties. Got to have non-metallic inner packaging, which of course makes sense because of the conductivity of metal. You've got to make sure it's stable. You have to have packaging that is meeting UN standards. And it's not just for international travel. That's really an adopted industry protocol for domestic travel, but especially, of course, for international shipping. You've got other criteria that goes into the type of materials that are going to be used for the packing and the stabilizing of it. What you do have, though, is an exemption for if you have strong outer castings, but it has to be for lithium-ion batteries weighing more than 26.5 pounds, and that otherwise are built with casings that meet all of the UN packaging. And if that is the case, then you do have some relief because of the type of battery, if you will, infrastructure that is already provided to avoid some of these other requirements. But again, it leads to compliance assurance determinations about the type of battery that you have. And there is quite a mix of batteries there. So there's not a uniform specification, as we all know, for the types of batteries that are in these vehicles. After all, there are 4 different forms of, if you will, electric vehicles, all with varying types of lithium-ion batteries in it. Looking for damaged and defective batteries, they step up the game a bit more in terms of what the packaging is for that. But the key takeaway from today is that there are separate packaging requirements if you have determined that the used battery falls into the damaged and defective category. We then look back or look forward to other handling of batteries. there's going to be handling, movement, storage within facilities, both of the new batteries during, if you will, the placement or assembly phase of their lifespan, as well as to the post use in a vehicle prior to making its way to one form of disposition. OSHA, or the Occupational Safety and Health Administration, which we're all more familiar with general employee standards, has some very specific environmental standards in several areas, because a number of employees are exposed to all sorts of chemicals, all sorts of wastes that are generated, particularly in intensely heavy manufacturing processes. No surprise, again, just because of their, let's say, hazardous nature in original form, that batteries also have their home within OSHA regulation, and in particular Li-ion batteries that are used in EVs. And the handlers of the batteries, well, first of all, I'm sorry, I want to draw your attention to the first point. There is a rather meaningless exemption that is saying that for lithium-ion batteries that don't exceed 50 volts, that they're not subject to OSHA. But the range of voltage for EV batteries on the low end is 400, high end presently from 400 to high end 800. So that's really an inapplicable, really not relevant exemption. So EV batteries are in for OSHA requirements. And then you've got really two types of handler regulation: those responsible for their movement and storage, and those responsible for actually performing work on the batteries. The OSHA has essentially 4 different areas of regulation under it that apply to EV batteries. The first is commonly referred to as hazmat training. There's all sorts of forms of hazmat training, again, for chemicals and all sorts of other aspects of industry, but there is specialized hazmat training that needs to be undertaken for employees involved in any sort of contact with Li-ion batteries. The facility that is in which EV batteries are being handled and stored is subject to emergency planning requirements. Citation to the federal regulation is there, and these are the same requirements to apply to storage of very high, highly toxic chemicals. The batteries, again, are essentially equated to having very hazardous chemicals on site and need to be treated as such. The HAZWOPER standards really are another form of training and procedures that govern how EV batteries are to be handled when there's an incident. And as we know from what's been in the press, and we just know about their properties, there can be thermal incidents or fires involved with them, but there can also be cracked casings where there are exposure and voltage exposure issues. I'll say the electrical risks that are involved in it. And for that reason, there are specialized procedures within OSHA that govern employees who have to respond on facility, whether it's during service of a battery or just during storage of a battery, where there is something that occurs. And akin to that, then, are the last standards, which get into fire suppression. As you know, with batteries, putting out a lithium-ion battery fire will consume and necessitate a lot of water. A lot of times, a salinated water or like a salt water is being used to neutralize the battery and the area. But usage of foams and other materials, just because of the nature of the battery, that might be applicable to other chemicals and other types of fires, where standard fire suppression measures for a facility are differentiated, again, because of the specialized nature of the lithium-ion battery. Looking at the handling requirements beyond federal and state level OSHA requirements, I also want to draw your attention that there are becoming more and more local public safety requirements, usually through fire departments, where they have their own requirements for what needs to be in place at a facility, essentially assurance requirements, largely that you've put in place everything for OSHA, but there can be different requirements or additional requirements due to the fact that there may be some specialized circumstances about where your facility is vis-a-vis a hospital, vis-a-vis resources like a river, a creek, wetlands, or whatnot that may come into play that would cause the local fire department to supplement that and review things. So that's very important to note in your local jurisdictions. The same goes for insurance. You cannot consider EVs in the same way as the decades of lead acid battery use and how they fall in a more vanilla manner under comprehensive general liability insurance policies, property insurance policies, and pollution liability insurance policies. You really do need to coordinate and carefully review your policies to have an understanding about what measures you need to have in place to trigger coverage just for storage of the batteries on site, that you don't want to fall short of the condition and be disqualified for that result, and also understanding as well what coverage can be triggered in the event of an incident, whether thermal event or otherwise. Getting on to the last area, which really is disposition. Disposition, as I say, includes the larger bucket of disposing of used batteries, of possibly recycling used batteries or material from used batteries for other uses than a reactivated battery, and then ultimately reclamation, which would be reuse of the battery for its original purpose or something very close to its original purpose of electrifying or powering something. The regulations for this really fall under the broad hazardous waste regulation that has been set up both at the federal and often delegated to state levels. So that is the basis of authority by which disposition of batteries in these three categories are all regulated. Batteries have long, non-Li-ion batteries have long been recognized as part of universal waste, which is kind of like the light regulations. You're still subject to hazardous waste regulations, but you don't need to manifest. You have certain lenience in terms of extra time for having them on site before you need to move them off for storage or recycling reclamation. Quantities can also be greater with universal waste. They apply to fluorescent lamps, to like paint cans. There are various forms of universal waste, and Li-ion batteries have been accorded coverage by universal waste, which is positive, notwithstanding their highly reactive and hazardous nature. The recycling of the batteries, which essentially is trying to extract from them reusable materials, has its own body of regulation, and that's cited here. And in the interest of time, I won't run through the slide, but I will say that there are specific provisions of recycling from lithium-ion batteries that can be followed and that can be done. And so not that there is a great market yet for recycling batteries, but at least we are seeing federal and state governments trying to support and facilitate what will ultimately, and we all hope to have, a more robust recycling market for lithium-ion batteries. And so the infrastructure is there, the regulatory infrastructure for that. Reclamation in the same light, even though there isn't yet a very robust cottage industry for reactivating lithium-ion batteries, there are regulations in place that provide for how you can do that and how you can move batteries around in a manner. So you're seeing, at least at the federal level, not regulations that are posing roadblocks to the evolution of this industry, but are doing their best to facilitate it. But as you move forward, you have to understand this is a very heavily regulated area. And the regulation of it is about to get heavier. And I'll close on this note in that there's been a proposal for intentions of rulemaking that came out last October, and that has not yet made its form into actual requirements, but the incidents and the frequency of incidents that the storage of used batteries is resulting in thermal events is really driving this. So what we're all anticipating is that both from ultimate disposal sites as well as storage, that there's going to be stepped up measures and protocols for how you can line areas to properly and safely store those batteries. So that concludes my segment on the environmental peek into the lion's den. And next, I'll turn it over to my colleague, Connor Walby.
Thank you, Grant, and good afternoon, everyone. I know time is running short, so I'm going to keep this brief, but I am going to talk today about electrical vehicle litigation trends and liability, some things that we've seen from the field, some trends that we're observing with respect to lawsuits and claims, and get into some of the best practices that we've formed as a result of those observations. So real quick, just to start off, to talk about some liability trends. And the first one that comes to mind is battery range and anxiety. This has been a hot button issue for consumers when they're going to buy a vehicle, and also when it comes to breach of warranty type claims. Folks are expecting or believing that they're going to get X range, and they probably do, and sometimes don't realize that if you play the radio and blast the AC, your range is going to go down. And so they've been bringing false advertising, misrepresentation type claims, again, in particular in the breach of warranty space. This is obviously an issue during the cold months because of the chemistry of lithium-ion batteries. The colder the outside environment is, the less range you're going to get out of a lithium-ion battery, and you're going to couple that with an increased demand in heat and other electronics throughout the vehicle. Secondly is a trend that we're seeing, or that we expect to emerge as EVs grow from a 10 to 12% of the vehicle segment now into a much larger segment as in the next couple of years, is the acoustic vehicle alerting system. For those that you have kept up on the trend, these are the systems that play noises that to mimic or imitate a moving vehicle as an EV is coming down. Unlike a traditional ICE vehicle, their EVs are much quieter to both the sound as well as when they're driving around. So, for example, Hans Zimmer and Mercedes-Benz, I believe, have teamed up, and when you drive a Mercedes-Benz down the road, you're actually hearing Hans Zimmer's orchestra play to alert drivers, pedestrians, emergency responders, etc., as you approach. So it's a repackaging or recycling of a classic failure to warn claim. But nonetheless, it's going to be applying to, again, passersby, people on the street that may not see it or hear an EV get hit and then bring a claim that, that they were not adequately or sufficiently warned of the oncoming vehicle. And again, as EVs increase in the segment and ICE vehicles reduce, we expect that to happen more often. So some other issues that we're seeing emerging: battery control, management systems, and charging systems. So the battery control module, for those that are aware, is both the brains and the heart of the connection between the high voltage system and your traditional 12-volt system in a vehicle. It sort of monitors the charging and the output of the high voltage system, as well as just overall keeping the temperatures within the system in a safe and environment. So with battery control module issues, usually that actually manifests itself in the 12-volt battery failing first. And we're seeing folks bring in with charging issues. They're unable to charge their battery fully, or it's unable to charge at all, or the 12-volt battery is dead because there's a parasitic draw there. And so they're bringing in their vehicles. They're unable to start up their BEVs and operate. And I want to point this out, that if for those that are on the OEM side, that if you are having a large volume of claims with regards to battery control modules, it's important to make very clear warnings to both the consumer and the dealer about what to do with the vehicle if there are charging or battery control module issues. This could be a sign, as we'll get to in a minute, of a potential thermal runaway event, which we want to avoid. So parking the vehicle outside, away from structures, is going to mitigate risk and mitigate the possibility that if a thermal runaway event does occur, there's less damage to either the home or the dealership. Again, if such an event occurs. Home charging systems. Again, we're seeing some interesting claims or accusations come out about whether the home charging system was sufficiently and adequately installed, and whether that is interfacing correctly with the vehicle. this hand in glove again to thermal runaway events, which we'll get to in a second. And so that we're seeing the automotive industry get dragged in a little bit into the home building industry, which is kind of unique. So again, so some of those claims to watch out for. And lastly, Mark talked a little bit about this data privacy and security. This is not necessarily an issue that's germane solely to EVs. Cars today now are more connected. They're more interconnected now than ever before. There's a lot of data that may be gathered from a vehicle. EVs just happen to be top of mind because they all run off of electricity. But where sort of the focus comes in is in the batteries themselves. The U.S. Department of Commerce launched an investigation this past February into Chinese battery manufacturers, the largest being Cattle and BYD. They're probably the largest battery manufacturers in the world, about maintaining and disseminating consumer data. So this is a two-pronged approach. One, we're worried about breaches of data, and two, we're worried about sort of a safety and a cybersecurity concern about being able to access the battery control module or data that's coming from and off of the high voltage system. So the hot button issue, again, I think is on top of everyone's mind, are battery fires. As the chart on the right shows, there's an SAE paper from 2023 that NHTSA teamed up with them to do. Battery fires happen relatively quickly when they do go up, and they produce a lot of smoke and they get really, really hot. For those that have seen thermal runaway events, it's a big bright flash and the fire goes on. But what we're seeing is battery fires perhaps are unfairly being treated in the news. They seem to be the top hot button issue. And why is that? Well, number one, these fires are likely occurring in the home or in the dealership, leading to a lot of collateral loss. Again, because the fires burn so hot and so quickly, it's harder to put out, as Mark and Grant alluded to earlier, leading to large damage claims. As well as we're seeing personal injury type claims. We're seeing the plaintiff bar get a little crafty here and saying, yes, my house did burn down. I did lose my car, but also I was exposed to lithium or cadmium or nickel or any of those other metals that are in the battery that were vented out during the thermal runaway event. So this is kind of a unique approach to vehicle fires that we have not seen before. It requires some extra expert involvement and something that's unique to EVs and battery fires. Real quick, just out of the interest of time, I won't spend too much on this, but you can go out and Google. I think this is going to be a watershed moment for South Korea, and I think we're going to see some copycat regulation here, if not claim. So last month, August 1st, there was a large fire in a high-rise apartment. The owner parked their EV in the basement garage of their residential tower, and the vehicle caught fire. It resulted in over 700 residents being evacuated and from their home. About 160 cars were lost, and 23 people were sent to the hospital. So Korea, in response to that, said, okay, first off, if you're in Seoul or Incheon, which are the two sort of cities next to each other where these fires occurred, you cannot park your vehicle in an underground parking garage if it's charged over 90%. And then secondly, if you have a vehicle and you're trying to charge it at a public port in the city, you cannot charge it over 80%. So they've capped the charging rate. So again, maybe this is the tail wagging the dog or the dog wagging the tail, but it seems that battery fires are going to be drawing regulation along with claims. And the last caveat here that's an interesting aspect to this fire is that the South Korean government, as of this month, will require car manufacturers to disclose the manufacturer of the battery and the component parts. That's often, in my experience, a pretty closely held secret, if you will. It's certainly out there. You can certainly go look, but to disclose it to the consumer is going to be interesting to see how that is dealt with in Korea and if it's going to be dealt with here in the United States. So lastly, as we investigate battery fires, there's some lessons that we've learned. If you're on scene, involve key personnel, make sure that it's a safe environment to be involved in, determine the state of charge. We do not want an arc flash or a reignition event. Involving your local DPSM or your field tech is absolutely necessary. They're the boots on the ground dealing with non-thermal runaway batteries. And so they're going to be more at times probably more knowledgeable than some of your in-house or external experts. Preservation and storage. Coordinate with a reputable handler if you're going to be removing a battery or a vehicle that still has its battery from a fire location. The packs are themselves are thousands of pounds. And so you want someone that is able to have the machinery and the knowledge and the capability to remove the battery or from the vehicle, or the battery and the vehicle together safely and efficiently. You don't want to pierce the battery to cause a reignition event. Contained environments, please separate. We've seen that if you separate the battery or the vehicle and the battery from other places, you're going to avoid some spoliation or some further damage from another reignition event. I put there on this side, a shipping container is a great idea. It's cheap, it's effective, and if there is a reignition, the only thing that goes up is a shipping container. Lastly, if you're going to be doing root cause investigations, if you're going to be extracting the modules from the pack, prepare for extra time and extra tools. Real estate is a premium in battery packs as it is. If you're going to be investigating a thermal runaway pack, whether the fire started in the pack or was just subjected to a fire, you're going to see at least some moderation of swelling of the modules, which are going to be going to make it difficult to extract, particularly if you don't want to damage the module and the cells they're in. If you have copper bus bars, those have to be removed depending on where they're laid in the pack. Oscillating saws are great, but again, takes extra time, extra expertise, and can be quite dirty and messy. Same thing with cross members in the pack. Those might have to be cut so you can safely access the pack. Last but not least, transportation. Grant hit this on the head. Make sure that you're relying on someone that's hazmat certified. This is a Class 9 hazardous substance that is required to be put in a UN Group 1 box. Surrounding with pyro bubbles or non-combustible, non-conducive material is absolutely key here. And lastly, finding a CT lab is hard to do. Not only are there a dime, they're not a dime a dozen, but also the CT labs that are around may not have the equipment necessary to scan a module itself. Depending on the size of your module, whether they're prismatic, pouch, or cylindrical, your modules are going to be quite large, and the CT scans may not be able to capture the entire module in one scan. So those are just more tips and tricks that we've developed as we're investigating and defending battery fires. I'm happy to talk more offline. I see my time's expired about things that we've seen and the best strategies moving forward. So if there are no other questions, thank you for everyone's time. And feel free to reach out to any of the presenters about any other questions, concerns, or if you'd like to talk about matters further. Thank you so much.